I just want to get this straight. The campaign finance expert wasn't allowed to testify about campaign finance.
Yeah, exactly. And, you know, the way Judge Mershon tried to explain it is he said, well, you know, I'm the expert of the law. And, okay, granted, that's why the judge is there. But
Brad Smith wasn't allowed to talk about the very testimony we just got from Commissioner Traynor, in essence.
Precisely.
Right? Well, we're going to give Brad Smith a chance to testify in front of this committee as well.
So as you said, it's Federal Elections Commission. Was President Trump's alleged payment via Michael Cohen to Stephanie Clifford referred to the FEC?
We did have several complaints related to it.
And what did the FEC decide with respect to that referral?
Well, ultimately, we deadlocked on a decision related to it, but the real factor in making the determination was the fact that the Department of Justice asked us to abate those proceedings so that they could conduct an over a year-long criminal investigation, which they determined there was no criminality in, and then they sent it back to us, and it was statute of limitations barred.
Hey everyone, welcome back to Congress Lens. I'm Audrey. After watching that clip, I have to say this. Jim Jordan was asking the exact question a lot of people are thinking right now. How does this make sense? If federal campaign finance law is central to the case, and the agencies that actually enforce federal campaign finance law declined to act, then why was a state court handling it the way it did? That's what immediately stood out to me. Jim Jordan was not just talking. He was walking through jurisdiction, what the Federal Election Commission did, what the Department of Justice did, and then pointing out what looks like a serious due process concern. And if a campaign finance expert is not allowed to testify about campaign finance law, that should raise eyebrows. We're going to break all of that down. If you care about how the legal system is applied in high-profile political cases, make sure you like this video, subscribe to Congress Lens, and share your thoughts in the comments after you hear this full breakdown. Let's get into it.
Gentleman from Wisconsin is recognized.
Thank you, Mr. Chair. Thanks for being here today, and I know we've been kind of going on. I'm trying not to rehash anything that's already been discussed, but Commissioner Traynor, is the Manhattan District Attorney's Office charged with determining whether someone violated the Federal Elections Campaign Act, or FECA?
No, Congressman, that is exclusive jurisdiction of the Federal Election Commission and ultimately could be referred to the Department of Justice if it's found to be criminal.
So certainly not the New York Supreme Court either, state Supreme Court?
Absolutely not.
No. So as you said, it's Federal Elections Commission. Was President Trump's alleged payment via Michael Cohen to Stephanie Clifford referred to the FEC?
We did have several complaints related to it.
And what did the FEC decide with respect to that referral?
Well, ultimately, we deadlocked on a decision related to it, but the real factor in making the determination was the fact that the Department of Justice asked us to abate those proceedings so that they could conduct an over a year-long criminal investigation, which they determined there was no criminality in, and then they sent it back to us, and it was statute of limitations barred.
So did the Justice Department also decline to charge the former president for charges related to FECA?
They did.
Right. And so the two agencies that are charged by Congress to determine whether President Trump's payment constituted a violation of FECA found no violation and took no enforcement action. Is that correct?
That is correct.
All right. Thank you very much. Ms. Foley, you argued in a recent Wall Street Journal op-ed that Judge Mershon likely denied President Trump a meaningful opportunity to be heard by denying the testimony of former FEC Chairman Brad Smith. Can you please elaborate a little bit on that?
Yeah, I mean, there's been a lot of sort of misreporting on what happened here. Yes, Judge Mershon, as my colleague, Mr. Eisen, points out, did allow Brad Smith to testify, but the catch was he could not opine at all, either provide his opinion or any personal opinion or legal opinion regarding whether or not President Trump's actions had violated FECA, which was basically, then he was useless, which is why President Trump didn't call him as a witness. So the whole point was President Trump wanted an expert witness to put before the jury to show the jury that what he had done did not, in fact, violate federal election law. And he was denied that opportunity, and that seems like a rather basic thing that he would have the opportunity to be heard on.
Do you think there was a chance that he could have had success upon appeal?
Will he have success on appeal of this? Yeah, sure, absolutely. I mean, the thing is that, you know, again, I agree with Norm on the fact that the bias issues are difficult to win because they get deferential standards of review. But the due process issue is a question of law. It gets de novo review. The appellate courts get to look at it fresh, with fresh eyes, no deference whatsoever. And more importantly, due process issues are issues that the Supreme Court can ultimately grant cert and hear.
Right, so Judge Mershon also ruled that Michael Cohen's guilty plea for violating FECA was inadmissible at trial. Why do you think he made that ruling? I think we know, but...
Well, because you can't basically taint one individual by the guilty conduct of another.
Judge Mershon also ruled that D.A. Bragg could elicit testimony from Mr. Cohen about his guilty plea to impeach his credibility as a witness. D.A. Bragg then repeatedly made reference at trial in his office closing arguments to the jury about Cohen's FECA guilty plea. Did repeatedly subjecting the jury to this testimony essentially get around the judge's own ruling that Cohen's FECA guilty plea was inadmissible as substantive evidence?
Yeah, I mean, that should have been reined in. That was
President
clearly
Trump.
trying to, taint one person through association with another who was guilty. They also did the same thing, I believe, with the CFO of Trump Organization. They made similar comments because he also entered a guilty plea.
Very good.
Weisselberg. Yeah.
Thank you. I yield back.
Will the gentleman yield? Will the gentleman yield? I do. Thank you. So I just want to get this straight. The campaign finance expert wasn't allowed to testify about campaign finance.
Yeah, exactly. And, you know, the way Judge Mershon tried to explain it is he said, well, you know, I'm the expert of the law. And, okay, granted, that's why the judge is there. But
Brad Smith wasn't allowed to talk about the very testimony we just got from Commissioner Traynor, in essence. right?
Precisely.
Well, we're going to give Brad Smith a chance to testify in front of this committee as well. And we're going to let him tell the Congress and the country what he wasn't allowed to tell the court and the jury, because we think that's important. And the gentleman from Wisconsin was right on target when he was asking that question.
All right. Now that we've watched the full exchange, let's really talk about what Jim Jordan did here. This was not just political back and forth. Jim Jordan laid out a clear timeline. First, he established that the Manhattan District Attorney's Office does not have authority over federal campaign finance law. That authority belongs to the Federal Election Commission, with possible involvement from the Department of Justice. Then he confirmed something important. The Federal Election Commission reviewed complaints related to the payment involving President Trump and Michael Cohen. The FEC deadlocked. The Department of Justice then conducted a year-long investigation and decided not to prosecute. So the two federal entities that Congress gave authority to enforce campaign finance law declined to bring charges. That matters. By the time the issue returned to the FEC, the statute of limitations had expired. No enforcement action was taken. Yet in state court, federal election law was still being used as part of the legal theory. That is where the concern comes in. Now let's talk about Brad Smith. Brad Smith is a former chairman of the Federal Election Commission. President Trump's legal team wanted Brad Smith to testify as an expert witness on whether the payment violated federal election law. Judge Mershon allowed Brad Smith to testify, but did not allow Brad Smith to give an opinion on whether the conduct actually violated federal law. Think about that. An expert in campaign finance law was not allowed to explain whether something violated campaign finance law. Jim Jordan summed it up clearly. A campaign finance expert was not allowed to testify about campaign finance. Then there is the due process issue. The argument raised was that limiting that testimony may have denied President Trump a meaningful opportunity to present a defense. And unlike claims of bias, due process issues are reviewed fresh on appeal. That is significant. Jim Jordan was also pointing out that while Michael Cohen's guilty plea could not be used as direct evidence against President Trump, the jury still heard about it during impeachment and closing arguments. That raises another question. Does repeating it in that context still influence the jury? Whether someone supports President Trump or not, the principle here is about fairness and consistency. If the agencies responsible for enforcing federal election law declined to find a violation, and an expert on that law was restricted from explaining it in court, people are going to question the process. Jim Jordan was not shouting. He was methodical. He was asking straightforward questions. And honestly, they are questions that deserve answers. Now I want to hear from you. Do you think the ruling limited the defense unfairly? Or do you think the court handled it correctly? Let me know in the comments. This is Congress Lens. I'm Audrey, and we will keep breaking down what happens in Washington and beyond, one hearing at a time.